We have more for Your Ears Only. I'm David Alpern.
I'm Melissa Axelberth with a quote from the news. "It's going to be all right, sweetie. I just want you to know I love you." That was Decatur, Georgia school clerk Antoinette Tuff talking a heavily armed man into surrendering after trading shots with police, but before any student or adult was hurt. Also last week, 2 Spokane teens robbed and beat to death an 88-year-old World War II veteran. And Australia's former Deputy Prime Minister Tim Fischer blamed U.S. gun culture for the shocking fatal shooting by 3 teens of a young Australian jogging in Duncan, Oklahoma the week before. Now this.
I apologize to my staff. I apologize to the citizens and staff members who have supported me over the years. I apologize to the people of San Diego. And most of all, I apologize to the women I have offended.
Back when the number of women accusing him of sexual harassment, or at least crude advances, was in single digits, San Diego Mayor Bob Filner was apologetic but defiant about not resigning. Instead, he said he'd undergo a week of counseling that most experts judged ludicrously inadequate. But the ranks of female accusers continued to grow, including a Navy admiral, a university dean, and an advocate for wounded war vets. And as the number neared 20 last week, Filner finally did agree to step down, with a settlement that will have the city share at least part of his subsequent legal expenses, and with another apology. This time he denied any crime and claimed to be the victim of, quote, lynch mob mentality and a political coup.
Also last week, court-martial proceedings moved ahead against a former Army Rising Star, Brigadier General Jeffrey Sinclair, on charges of adultery, conduct unbecoming, and forcing a longtime lover and subordinate to perform oral sex. To discuss the issues of workplace sexploitation raised by both cases against a background of growing pressure for reforming military handling of all too common sexual assaults, for Your Ears Only, we're joined by workplace attorney and media analyst Sonya Madison of Atlanta. Welcome to the program.
Thank you, David and Melissa, for having me.
The requirements for proving sexual harassment include, quote, severe and pervasive unwanted conduct based on sex. Does it seem to you from what the women involved have described that Filner's follies did rise to that level of offense?
Yes. I mean, you had the initial person who filed the lawsuit, and she articulated several instances of sexual advances, calling her his future wife, of wanted to consummate their future marriage and touching and groping her. And with 16 to 18 people then coming out afterwards, I don't doubt they would have been able to show repeated, pervasive conduct that was unwanted.
In some other recent cases of politicians behaving badly, it's been suggested that some of the younger women involved were eager for the attention and even the subsequent publicity. So I assume you were not surprised that the more senior and really highly placed women Filner hit on were not eager to come forward with complaints.
No, I wasn't. And in fact, some of the women that you mentioned that were part of the military personnel, they were previous victims of sexual assault. And they even said, we didn't come out initially because we were already wounded and hurt by the initial assault that we received. And we thought that this person was an advocate on our behalf. And when he proceeded to disrespect us and do inappropriate conduct towards us, it just shied us away or prevented us from coming forward because of that fear that was already initially there.
Having charges of sexual harassment on your record is clearly a negative for future hiring, but is the same true for a record that shows you complained about such behavior?
Well, usually you're not supposed to, as an employer, you're not supposed to know if someone filed a claim for harassment or discrimination or any of the like. Whereas if you are someone who's been accused and you were terminated, usually a employer is going to ask, why were you terminated, and something like that may come up. Or if they seek a reference from your previous employer, that information may be forthcoming. But even if your potential employer finds out, you are protected against retaliation. And while I can understand a lot of applicants may feel as if, well, will I be able to prove it? Because the Supreme Court just recently issued a case saying that if you want to show retaliatory harassment or retaliatory conduct based on harassment, you have to show that is the sole reason why you didn't get the job or you didn't get the employment action. And so it may be difficult, but yet there is some protection for those who have filed the charge for harassment and then want to seek additional employment elsewhere.
What is the best way to make a complaint of that sort, and what do you need in terms of records or evidence?
Well, if you are in an employment setting that is not the military or does not public employer, then you should first contact your human resources or contact your supervisor, letting them know of the conduct. And if that doesn't cause any additional preventions, or if the action is not corrected, then you either should go to the Equal Employment Opportunity Commission, which every state has one, or you should seek an attorney. An attorney can then file that charge and do some investigation, or decide to just go forth with the lawsuit.
How long do you have to file such a complaint?
It will depend. If your state has discrimination or anti-discrimination statutes, you could have up to 300 days. If your state doesn't and you're going to file in the federal law, you have 180 days from the time the harassment occurred. So the minute that you know I'm being harassed right now, the clock starts ticking. Now, if the harassment continues, you can then say, well, this was an ongoing thing, and you can use all of it, even if it's past the 180 or 300-day mark. But if it's just one instance, which usually won't rise to the level of harassment, then you have until the time that incident occurred to file your claim.
Switching to the problem of sexual harassment and assault in the military, which of the approaches that have been considered by Congress would you think most effective? Having military prosecutors rather than commanding officers decide what cases and charges should be brought at the start, or having such experienced prosecutors preventing a commanding officer from dismissing a guilty verdict once it's been handed down?
If it's dealing with harassment, kind of like the workplace harassment, I do think it's best to then have the commander so that they can try to dissolve it internally and then take some sort of corrective action. But if you're talking about assault or rape, you really have to balance what's best for the victim versus what's best for the military. And in this instance, if I was a victim or if I'm trying to make sure other people do not have to go through such things, so I would rather go to a uniformed prosecutor. I'd rather get such crimes like that outside of the whole military or outside of the area that is being conducted, get those third parties involved, because it is a very serious crime, and you're talking about victims who have been internally hurt, who are going to continue to suffer psychologically, and who have just had their rights completely invaded.
Sonya Madison is a workplace attorney and media analyst in Atlanta.
Quote from the news, "It's all about a crappy thing that didn't work, damn bugging." That was an increasingly distracted and distraught Richard Nixon on the Watergate break-in that a year later would lead to his resignation and one of the last of his White House tapes to be released. Elsewhere in the recordings, he speaks of West German leader Willy Brandt as a jerk and sneers at American Jews more loyal to Israel than to the U.S.
Next, Sing You Sisters, Liz and Ann Hampton Calloway on their performance Together and Apart for Your Ears Only.